IRAs are different both during your lifetime and for your estate. During your life, IRAs, unlike other assets, defer taxes on gains until you retire. IRAs are distributed differently from all other assets both during life and after death. IRAs have required minimum distributions, beginning at a certain age, currently 72. There are no loan provisions permitted from IRAs. Hardship withdrawals are permitted, but the rules are different from the hardship rules for 401ks. IRAs are highly taxed upon death or withdrawal, in addition to possible IRS penalties that can apply to withdrawals made by the owner. IRA investment gains are taxed as ordinary income, not at capital gains rates. IRAs cannot be owned jointly like other property, even in community property states. IRA equity cannot be tapped the way home equity can be tapped, without triggering tax and potential IRS penalties. IRAs cannot change ownership during lifetime. This would trigger an immediate and complete distribution and end the tax deferral. IRAs cannot be gifted or transferred during lifetime. Here are a couple of exceptions. 1, a direct gift to charity, a qualified charitable distribution, which has its own set of rules. 2, a court-ordered transfer that is part of a divorce agreement. Estate planning is also different for IRAs. IRAs have their own set of complicated distribution rules, both during life and after death, and these have been changed recently by the Secure Act. Your estate plans for your IRA may need updating more so than most of your other assets due to the Secure Act. IRAs receive no step-up in basis. They remain fully taxable to the beneficiary who inherits them. An owner's IRA is subject to double tax at death, federal estate and income tax, plus state versions of these taxes. It's very important to carefully designate your IRA beneficiaries, because that will ultimately determine the future potential value of your IRA to those beneficiaries. Often, when you're setting up a revocable trust, your attorney may advise leaving everything to the trust. Even though this seems simple and logical, there are reasons to think carefully before naming your trust as your IRA beneficiary. Here's why. Similar to life insurance, IRAs pass by contract, generally not by will. In other words, your IRA will pass to the named beneficiary rather than according to the language in your will. Individually named IRA beneficiaries may qualify for special tax breaks that could be missed if the trust is named beneficiary. So even though you may plan to have most of your assets go to your trust, give some thought to the flexibility provided by your IRA beneficiary designations. And don't forget to review those beneficiary statements annually. If you have a particular reason for naming your trust as beneficiary, know that trusts must qualify under specific IRS rules so that the trust beneficiaries are eligible for stretch or 10-year benefits. Even trusts that were set up properly just a few years ago may not work as planned after the changes made by the Secure Act. Please review with your estate legal professional team. It's important for your IRA to have its own estate plan and that the IRA be coordinated and integrated with the overall estate plan for the rest of your assets. If you need help understanding the complexities of IRAs, click on the link below to schedule a time with us. Thanks for listening.